and the remaining reserve lands in Clause 7 actually goes to Ngāti Pawa. That is not clear in this bill, sir.
Phil Twyford.
Mr. Chairman, I wanted to make some comments in my final contribution to this part on the part of the bill that revokes the Reserve Act. So in Part 2, it's Section 6(1)(b), which basically revokes the reserve status of the bill under the Reserves Act. And make the point, sir, that in cutting across the Reserves Act, what this bill does is basically circumvent an established democratic process that's there, that's written into the legislation, that's precisely there for the purpose of dealing with a situation where the government wants to repurpose some reserve land in the way that the government has the intent here. The point I want to make, sir, is that it's unnecessary. The bill is unnecessary given that that democratic process already exists. By cutting across those rights that are enshrined in our legal system, it undermines the rule of law and confidence in the legal and the planning systems, sir, and that is very unfortunate. So what is the existing statutory process? Well, it exists under the Reserves Act 1977. All it requires is for the Minister to undertake consultation with the administering body, that would be Auckland Council, and the public, before issuing a Gazette notice advising that the reserve status will be revoked. Affected parties have the right to object to the revocation, and decisions of the Minister may be judicially reviewed. Well, if the government is so sure of itself that this is a good thing to do with this particular bit of land, if it's so convinced that the public policy purposes stack up, if they're so convinced that it's going to be socially and environmentally the right thing to do for the community, why won't the government subject this proposal to the normal statutory process that exists under the law? The next thing I want to do is basically talk about the cutting across of the RMA in this proposal, and the provision in the bill which essentially changes the zoning. From the commencement date, it changes the zoning from public open space to mixed urban housing. It just cuts right through the provisions of the RMA. So what is the existing process to do that? Well, what would happen normally is that a developer would request that the Auckland Council make a plan change under Part 2, Schedule 1 of the RMA. And it would have to, that plan change would have to consider a number of factors, sir. The effects on the neighbourhood and the wider community, the physical effects on the locality, including the landscape and visual effects, the effects on the ecosystems, the effects on natural and physical resources, and a description of the mitigation measures to prevent or reduce those effects. Now, wouldn't you think that was a good thing? Wouldn't you think that all of those factors that are enshrined in the RMA and the established democratic processes for a proposal of this sort, wouldn't you think they were good things to be considered? I would, sir. And I say to you, and I want to quote a submission from the to the Select Committee by Jen Vella, who is a resident of Point England, lives there with her family, and she's a resource management lawyer with over 15 years' experience. She told the Select Committee that there are existing processes available to achieve all of these outcomes. They would ensure a robust assessment of this proposal. But the bill and the Select Committee process has done none of those things. There was no robust consideration of the evidence on all of those factors that I've just set out. She makes the point that overriding the normal established processes to achieve the government's objectives in this case undermine the rule of law and undermine public confidence in the Resource Management Act. I want to finally acknowledge in this contribution Sir Sean Lee, who made a number of submissions to the Select Committee on the environmental consequences and the effect of this bill on the breeding habitat of one of New Zealand's most endangered species, the northern New Zealand dotterel. There are only 2,000 odd birds left on the planet, and actually about 20-something of these birds live and nest on the land at Point England. The development that this bill will enable will destroy 50% of their breeding habitat. There has been no consideration of the environmental consequences of this bill.
Barbara Kuriga.
I move that the question be now put.
The question is that the question be now put. Those of that opinion will say aye.
Aye.
To the contrary, no. The ayes have it. Members, we come to the vote on part 2. First, we have the Minister's amendments as set out on SOP number 321. And the question is that the amendments be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party votes called for. I'll ask the clerk for a party vote.
New Zealand National.